Hello students, this is topic number 4, consideration in contract. Very important topic for exam by Professor Advocate Advhemas. Now, free consent cases etc. we'll be doing in the class. Consideration, definition, that's exactly give and take. Now, according to the law, consideration is a price for which the promise of the other person is to be considered. Consideration should be lawful, should not be prejudicial and affecting public interest. Now, void contracts we did was contracts that are not enforceable in the court. Example, minor's contract is void ab initio. Unsound mind, contract with the person of unsound mind is void. Declared an insolvent, entering into a contract which declared an insolvent is void. Agreements in restraint of trade, agreements in restraint of marriage, agreement in restraint of legal proceedings, all these are void contracts. In other words, there is no remedy in court. Now, quasi contract. Quasi means agreements that resemble a contract. So that's number 1, supply of necessaries to a minor. Number 2, payment by an interested person for protection of one's interest. Number 3, bound to pay by law obligation. Number 4, to pay for non-gratuitous act. Number 5, responsibility of a finder of goods. Now all these things, they resemble a contract. For example, if something is given to a minor, food, clothing or shelter, then of course it has to be given back by selling off the minor's property. So quasi contracts are contracts that resemble a contract. Contingent contract. Contingency means happening or non-happening of a certain event. So example we can take is Mr. Bachchan promises to give Pratiksha his bungalow to Abhishek if he marries Aishwarya. Here the contingency is if he marries Aishwarya, then he gets Pratiksha. Non-happening of an event, Mr. Bachchan promises to give Pratiksha his bungalow if Abhishek does not marry Bipasha. So, happening of an event or non-happening of an event. It's just for an example that you will understand. Contingent contract. Yes, time as an essence of contract. In every contract, time is always mentioned in the clause. If the contract is not performed within the time prescribed, the aggrieved party may approach the court for damages and specific performance. We'll be doing the case of KEDA operations where an elephant was contracted to be delivered for lumbering, but on time, on the day of the delivery, 2 days before, it was mentioned that the elephant could not be delivered and hence a breach of contract was filed. So this is a very important case where in contractual obligations, section 55 of the Indian Contract Act, time is an essence of contract. Similarly, anticipatory breach of contract, when a specific time is stated to perform and if one of the party fails to perform as part of the contract, then it's a breach of contract. On the date mentioned, a suit can be filed. Or the party can beforehand file a suit when the other party informs about the inability to perform his part of the promise. In anticipation means beforehand, before the time the party to the contract mentions that he is not in a position to perform the duty. Again, Budrachan versus Betts, that is case of the KEDA operations, elephant to be delivered for lumbering can be done. Now, breach of contract, types of breach. Contract is said to be breached when any of the party does not honor the terms of the contract. So, honoring the terms of the contract. Number 2, refuses to perform. Actual breach, promisor refuses to perform on the due date, claim compensation. Anticipatory breach, the promisor refuses to perform before the time for performance. Promisee may cancel or keep alive the contract till the date of the contract. Very important term is quantum merit, that is remedies of breach of contract. How much of work I did, you need to pay me. That is quantum refers to quantity, Remedy has been given to the other party who suffers the breach. Merit means work done. As much as done, compensation. In Hindi, we say it, jitna kaam utna bharpai karna. So how much ever work is done. For example, I get a contract to make your bungalow. I completed half the work. I report now later half I can't perform. Since I have constructed half, you may appoint a new contractor. So that is, as much as work done. Just judge your contingent or breach of contract. In this case, my contention will be considered. So you need to be compensated quantum merit as much as work done. You need to pay me for the 2 stories that I completed. Now, remedies for breach of contract. Number 1, very, very important. You can claim damages in the court, exemplary damage or nominal damage. Number 2, rescission of contract. You can resign the contract, that is discharge of promise. Number 3, you can file a suit on quantum merit, that means jitna loss, utna you have to pay. Suit for specific performance under the Specific Relief Act. Now, suit for specific performance, for example, a producer signs SRK as a hero and the story is designed, enters into a contract, but SRK cancels. Bringing unit, booked up crew members, incurred lots of costs. Yes, the producer can go to court, get monetary compensation, damages, but insist on SRK since he has created a character putting in mind. So, yes, here he can go in for Specific Relief Act, that is specific performance of the contract, if the compensation will not help. Hence, when monetary compensation is not sufficient, as the contract is personal in nature, skill is essential, hence court will ask for specific performance of contract. We'll be doing the recent case of Kedarnath in the class. Now, suit for injunction, remedy that an aggrieved party can claim under the Specific Relief Act. Number 1, to stop, to refrain. Number 2, files a suit, court orders injunction. Number 3, makes of serials may contract with actors that they cannot duplicate style. The Specific Relief Act gives the party, number 1, to stop or to refrain. Number 2, to file a suit for injunction under Section 6 of the Specific Relief Act. Example, Mona Singh prohibited from going to public in a normal look as the character in Jaise Jaisa Koi Nahi. So, nominal damages, ideally when there is no loss. In such a case, the party accepts there won't be any loss. This will lead to mistrust and indiscipline. The law wants smooth functioning of the contracts. Thus, nominal damages are ideally when there is no loss. The party accepts there won't be any loss. This will lead to mistrust and indiscipline. Exemplary damages are vindictive damages, that no one should do this offense again. Exemplary damages for maybe even the mental torture, the agony, the distress, or financial loss. Contract to marry is not a business contract. A contract with baby to marry her. After a month he says he can't, so intention is important. Depending on the mental stress, agony, or grief party, the court grants damages. Discharge of a contract. Number 1, performance of contract. Number 2, part performance of a contract. Number 3, novation, when a new contract is substituted for an existing one, either between the same party or new party. Rescission, rescinding the contract, that is when all or some of the terms of the contract are cancelled. Alteration, when one or more terms of the contract are altered. Thank you.